After discussing all the five writs that are falling under Article 32 and under Article 226, now we'll discuss the very differences that we found between those writs. So, in that connection, we'll first discuss the very difference between Cietorary and mandamus. The writ of Cietorary is issued to demolish the order passed by the inferior court or tribunal illegally, while mandamus is issued to compel the performance of duties of public nature. Mandamus may be issued even against administrative authority, but Cietorary cannot be issued against purely administrative authority. However, in certain condition, it is issued against administrative authorities, while mandamus is issued to compel an inferior court or tribunal, etc., to perform its public duty, while Cietorary is issued to quash the decision given by the inferior court or tribunal or body exercising judicial or quasi-judicial functions, or in excess of jurisdiction, or in violation of the principles of natural justice. And now we'll discuss the very difference between Cietorary and prohibition. As prohibition and Cietorary are similar in many respects, both are issued by the superior court to the inferior court or tribunal or body exercising judicial or quasi-judicial functions. Both are issued on the similar grounds. The object of both the writs is to restrain the inferior courts or tribunals or bodies exercising judicial and quasi-judicial functions from exceeding their jurisdiction. However, the main difference between prohibition and Cietorary is that prohibition is issued before the proceedings are completed, while Cietorary is issued after the decision is given by the inferior court or tribunal. They are issued at different stages of the proceedings. If the proceedings before the inferior court at different stage and the inferior court or tribunal are not completed, then the aggrieved person may move to the superior court for prohibition, and the superior court may issue prohibition to forbid the inferior court or tribunal from continuing the proceeding. But if the inferior court or tribunal has heard the matter and given a decision, and thus the proceedings are completed, the aggrieved person may move to the superior court to issue Cietorary so as to quash the decision given by the inferior court or tribunal. And now we'll discuss the very differences between prohibition and mandamus. Prohibition is issued to forbid the inferior court or tribunal or body exercising judicial or quasi-judicial functions to continue proceedings therein in excess of its jurisdiction, or in contravention of the law of the land, or in contravention of the principles of natural justice, while mandamus is issued to compel inferior court or bodies or persons to perform their public duties. Mandamus thus requires inferior court or person or body to act, while prohibition is issued to prevent the inferior court or tribunal from exceeding their jurisdiction, which is not legally vested therein, while mandamus demands some activity on the part of the body or person to whom it is addressed. Prohibition commands inactivity. Also, prohibition lies only against judicial and quasi-judicial authorities, but mandamus lies against public authority including administrative authorities. Mandamus may be issued even against administrative authority, but prohibition cannot be issued against purely administrative authority. However, in certain conditions, it is issued even against administrative authorities. So, these are the very differences we found among prohibition and cietorary, and between cietorary and mandamus, so also between cietorary and mandamus, and also between prohibition and mandamus, as those writs already we have discussed. So in our next edition we'll discuss regarding those original or ordinary remedies, or those equitable remedies which are available as private law reviews.